Right now, serious questions are being raised about how the Justice Department is handling the Epstein files and what that could mean for Donald Trump. Something significant just happened. The DOJ made a striking public statement about documents tied to Jeffrey Epstein, specifically, files that may reference Trump and past allegations involving minors. And buried inside that statement is a detail that changes the entire conversation. One of the legal justifications the DOJ is using to withhold certain documents, an ongoing federal investigation. Let that sink in. If documents connected to Trump are being withheld under that category, what does that actually imply? Is there a genuine active investigation, or is that language being used as legal cover? To be clear, there is no public evidence that Attorney General Pam Bondi or FBI Director Kash Patel are actively investigating Donald Trump. No official announcement has been made. But here's the question that matters. Is the DOJ citing an ongoing investigation as a way to block release of specific Epstein-related records? Because that's exactly one of the categories they're pointing to. They're also invoking something called deliberative process privilege, a legal doctrine protecting internal government discussions. Critics argue it simply doesn't apply here, not to witness statements, not to victim interviews. Some observers are going further, accusing the department of a coordinated effort to shield politically sensitive information. That's a serious charge, so let's walk through it carefully. The DOJ's Rapid Response account posted a statement pushing back hard against Democrats on the House Oversight Committee, accusing them of, quote, misleading the public and manufacturing outrage. The department insisted nothing has been deleted from the Epstein files. Documents may be temporarily pulled to redact victim information, they say, but are later restored. According to the DOJ, all responsive documents have been produced, unless they fall into one of three categories: duplicates, privileged materials, or records tied to an ongoing federal investigation. Those three exceptions are where things get complicated. Start with duplicates. Lawmakers have identified specific FBI 302 reports, official summaries of witness and victim interviews that are missing. These reportedly include statements from a person who accused Donald Trump of sexual assault when she was a minor. If those documents are genuinely missing, calling them duplicates doesn't work. A duplicate requires an original to exist. If the original isn't there, that explanation falls apart. Then there's privilege. What privilege applies to an FBI interview summary? It's not attorney-client communication. It's not internal policy debate. A survivor speaking to an FBI agent is not a deliberative process. And then there's that third category, the one raising the most eyebrows: documents tied to an ongoing federal investigation. Democrats on the House Oversight Committee have asked the question directly. Are you saying there is an active investigation involving President Trump? Because if that's the reason certain records are being held back, that would be explosive. Now here's another layer worth noting. On January 4th, 2026, weeks after the deadline set by the Epstein Transparency Act, a memo was issued by Deputy Attorney General Todd Blanche. Blanche, who previously served as Trump's personal criminal defense attorney, is now the second highest official at the Justice Department. The timing is hard to ignore. Under the Transparency Act, the files were due by December 19th. This memo arrived weeks later, instructing DOJ and FBI staff on how to review, mark, redact, and potentially withhold documents. The memo does outline protections for victim identities, entirely appropriate, but it also details how to categorize documents for withholding. And here's what stands out. The memo explicitly states that embarrassment, reputational harm, or political sensitivity are not valid reasons to withhold records. No document can be delayed or redacted simply because it could damage a public official's reputation. That's in the memo itself. It then lists 5 permitted categories for redaction: victim information, child sexual abuse material, records tied to an active federal investigation, graphic imagery, and classified national security information. Those are the rules. Now focus again on category 3. If the DOJ is using active federal investigation to block documents connected to Trump, then logically, some form of federal inquiry would need to exist. If it doesn't, critics argue the justification doesn't hold. Meanwhile, questions remain about those missing FBI 302 reports tied to allegations involving Trump and a minor. Lawmakers have published document manifests with highlighted entries that have never been released. The DOJ says nothing has been deleted. But the question persists: why are certain documents still not available to the public? Is it redaction for privacy, classification, an active investigation, or something else? At the heart of this is transparency. The Epstein case has already shaken public trust in American institutions. Now, with high-profile political figures potentially named in unreleased records, the scrutiny is only intensifying. The Justice Department says it's following the law. Critics say the law is being stretched, and until every responsive document is either released or clearly justified under the statute, this story isn't going away. Because when it comes to the Epstein files, every missing page raises another question. And right now, the biggest one is simple. What is being withheld, and why?